All right. Good afternoon, and thank you for tuning in. So, I wanted to first of all, I apologize that I haven't been online for quite some time. Things have been just absolutely crazy with everything that's been happening with the virus, with the closings, with issues. It's gotten to the point where, unfortunately, some of my association clients have their management companies being threatened by members of the community physically for not opening up the facilities, threatened on Nextdoor and other social media, and it's really to the point where it's not only outrageous, but it's sad that people are going to that extreme, blaming management companies for actions that boards are doing for their health, welfare, and safety of all their members. So let's talk about where we're at, my issues of my topics today. I'm going to again address this whole issue with opening up your recreational facilities, including pools, tennis courts, basketball courts, kids' playgrounds, all common facilities. As most of you know, June 1st, June 2nd, the emergency orders are being lifted by the governor, or they'll be set to expire automatically. With respect to the Division of Land Sales, which governs condos and to some degree homeowners associations, but really condos, the division also is taking no position on what the boards can or can't do moving forward regarding these emergency orders. So, excuse me, if everything expires, if the emergency part expires this coming week, what as a board, what as an association are you to do, and how are you to do it? Obviously, what I'm going to give today as advice and thoughts and work out with some of you, hopefully you'll participate, and I look forward to getting some questions and answering those questions. It's all going to depend on your specific situation. Every association is a little different from the other, but you share a common cause, a common issue. You as a board, and that's who I'm talking to right now, board members and managers, you as a board and managers are looking at situations where people are frustrated, they want to get out, and they don't want to have to go to the beach, they don't want to have to leave the premises, they want to be able to go downstairs, to go across the street, down the block, and use the facilities that they're paying for out of their assessments. So let's deal with that issue first. That's a really important issue. When an owner says to you, I'm going to stop making my payments because I'm not getting the full services of the association, you tell them, sir, ma'am, you can't do that. Whether you are provided the what you believe are the amenities of the association, the services of the association, you still have an obligation to make your assessments. You still have an obligation to make your payments, and that doesn't have one to do with the other. If you want to litigate that issue against the association, you're welcome to do so, and we'll raise our defenses. We'll go through why we're doing it and how we're doing it, but you can't unilaterally decide not to do it. Very, very famous case. It's the Abbey Park Bowen case, and that basically had a case to do with certain security facility amenities that the association was to provide but weren't working, and the owner says, you know what, if that's not working, I'm not paying. And of course, the court said that has nothing to do with one or the other. Your obligation to pay your assessments is separate and distinct from the association's obligation to provide you the services for those assessments. So in order to do that, you pay, association provides. If you don't pay, then the association can foreclose on your residence to make you pay. If the association doesn't provide, you can sue the association and prevail upon a court to order the association, if it finds that it hasn't done so, to provide those services. And of course, as the prevailing party, you could be entitled to your fees and costs, your reasonable legal fees and costs. So that's the Abbey Park case, and that really is a staple on when you deal with these types of issues going forward. So let's talk now really about, and these are themes that we've gone over and over again, but I'm getting calls all the time. How do we deal with this? So the first thing is I've had a number of associations want to have owners execute agreements not suing the boards. Why is this? Because most, if not every one of your insurance policies has a section that specifically excludes fungi and bacterial infections, damage, injury from coverage. So when you have that as part of your documents and somebody gets an infection, a COVID infection, they are not going to be covered. Obviously, if somebody got the flu while at the association pool or basketball court, you wouldn't think twice about it because most people don't die from the flu. Obviously, most people don't die from COVID either, but some do, and the rate is much higher than it is for the flu, as we all know. And the injury, the long-lasting disabilities that may happen to some are more drastic, more intense than they are for the flu. So people may tend and will look to be more litigious if they get an infection, because the infection of COVID-19, because they feel that you as the association didn't do what you were supposed to do. So what are you supposed to do? Well, in a perfect world, you're supposed to have the CDC come in with its personnel and train each one of your people to provide somebody to oversee the number of people at the facility that you're opening, basketball, tennis, playground, pool. Ensure that no more than 10 people congregate together. Ensure that nobody other than family members be 6 feet apart. Ensure that everybody wears a mask. Ensure that everybody disinfects and uses bacterial, it's hand sanitizers and so forth for the area. Sprays everything that everybody uses. And ensure that everybody is being safe and healthy about it so it doesn't spread even if somebody inadvertently comes to the facility without knowing that they are infected, or at least a carrier that can infect others. Maybe they're asymptomatic. What's the reality? The reality is you can't do this. Even my high-end associations don't have the means to divert from their budgets for what it would take for the manpower to put a person at the pool, especially, or at a park facility, or at a basketball court, or at a tennis court on a full-time basis to say, hey, guys, please, 6 feet apart, please, masks, please, spray, please, hand sanitizer. Nobody has the means to do that. I know that there's been some suggestions that you can use video and monitoring, a camera and so forth to monitor people. Absolutely, you can. What happens when there's that violation? You need to then send somebody out there to take care of that. One of the thoughts now is that since these restrictions are being lifted, the bathrooms should reopen. So your members will say, look, this is a homeowner association pool or even a condo in a big building. I don't want to have to go all the way up to the 10th floor or 9th floor. I don't want to go 2 blocks down. I just walked here with my family or get in the car. I'm all wet. I want to use the restroom. Open up the bathrooms. Who's going to make sure that when they leave, it's disinfected, it's sprayed? Who's going to make sure that they took care to do that inside? Is somebody going to watch them? Is somebody going to come in there and clean the entire bathroom after everybody has a singular use of that? Obviously, these are things that right now are simply, hi sir, how are you? Are simply not possible to handle, not possible to oversee, not possible to enforce. So what should you do? So some associations have suggested, and I've looked over these documents, I, Guy Shir, as a member of XYZ Association, agree that I am not going to sue the association for COVID or that I may get using the pool, coming out here to the pool. Is that enforceable? I don't believe so. I don't believe that you can waive somebody's rights to use association property, which you as the board are opening up. Because by the process of opening up, I believe you're telling the members, hey, it's safe to use it, or it's relatively safe to use it, or we think it's okay to use it. And once you do that, once you come to that factor of go ahead and use it, you become responsible to the members because they're entrusting the workings of the community, including the usage of the community facilities, to you, the board. You, the board, make these decisions. Owners don't. Owners make decisions of capital improvements, material alterations, potentially a special assessment. Well, special assessments are board, but if you're doing it for a purpose of not maintenance and so forth, that maybe is a capital improvement, then potentially under your documents, owners are involved in those processes. But when it comes to access or ingress or egress to these facilities, you as the board are tasked with saying yay or nay. So how are you going to make these decisions? How are you going to enforce this? And how are you going to tell your owners what to do? Well, first of all, you're not going to get them to hold the association harmless, and you're not going to get them to indemnify, and you're not going to get them to waive their right to sue. I don't believe any of that is enforceable. And more importantly, think about the potential litigation. Let's kind of play that out quickly here. Guy signs it because me and my family and I want to go use the pool desperately. We're dying here. I sign it. My neighbor, Joe, looks and says, I'm going to use it with my family. And the association says, no, you got to write it down. You got to write that you waive the right to sue us. I'm not going to waive the right to sue you. If you're opening up the pool, you better make sure it's done right. Well, I don't care. You're not using it. Well, where does it say in the covenants that you can do this? These are emergency powers. Judge, the emergency powers that the association has, I understand. They can close the pool, open the pool, mandate use of the pool, but they can't make me waive my rights, can they? Judge comes back and says, no, sir, I don't believe they can. I believe that you have the right to use the pool if the association opens it, and you don't have to waive any rights you may have because you're using the pool. And that, honestly, is what I think would happen. And I think most of my brothers and sisters who do what we do, my colleagues, agree with this position that you can't waive. Obviously, if there's a litigation and you want to settle a case with an owner, you and the owner can waive certain rights to sue forward and settle and so forth. But this is not an ongoing litigation, nor could it be until such time as it becomes one. So in other words, if we have a dispute and you want to settle that dispute, fine. But if you're giving Guy the right to use the pool and he signs it, but Joe doesn't want to sign it, and Joe says, I have a right to do so, I don't think the judge is going to agree that if we settle it now you can force him to do so. I don't think Joe and his family, as well as Guy and his family, have a right to use the facilities if they're open under the edict of the board, and that's where your powers continue through this pandemic, through, I believe, post June 1st, 2nd. Your powers continue, and this is where you can go ahead and administer the rights and boundaries of that use. You can't mandate, you can't make it tied into people signing off their own rights. So how should we handle this? I have actually come up with, I think, terrific language that really helps now associations put people on notice that there's a pandemic, that no matter what happens with the governor's orders, our association, and this is why this is tailored to every individual association, our association has certain limitations that we can put forth to allow the opening of the pool. For instance, we're going to remove all furniture, even chairs. There will be no chairs, no furniture. You as an owner must bring your own chairs, bring your own mattress, like a pillow, a blow up, something to sit on more comfortable that you bring and you remove when you leave. As an owner, we expect you to bring either gloves or some type of hand sanitizer for those areas that you touch of the pool gate, of the basketball gate, of the tennis court gate, whatever it may be. The biggest issue in mandating all this is working with the board to set up rules and regulations that you then espouse on the owners as to how they're going to use these facilities. And again, we spoke about this once before. You need to come up with time limitations, sign-up sheets, ways in which your whole community has the ability to use the facilities fairly within a reasonable time of each use, and then what happens going forward when somebody else is using those facilities. So what have I proposed and what I've done for a number of my communities? I've set up documents that we send by email for those who are on email, mail to those who only get by mail, post in all of the common elements areas that are frequented by owners, billboards or posting boards, not billboards, but a posting or a notification board for HOAs. If you have central mailing at the central mailboxes, if you have security when you come in at the security post. We've also put them in lobbies of condominium buildings, billboard boards or posting boards of condominium buildings. And most importantly, you need to laminate these instructions, you need to laminate these rules and regulations and put them at your facilities that you are now contemplating opening. So let's do the one example. I don't like to make these too long and get boring and have to listen to me babble and babble. So let's focus on the pool. The biggest issues out there. I think this goes to all the other ones. So for the pool, what I recommend is one, you show some type of you show some type of distancing of the 6 feet, okay? And you put there the rules and regulations, and you especially put in, and the biggest issue that you're going to put in there is, we're opening up the pool. We recognize the following, and we go through, and I have a whole thing that I provide my clients that we are discussing that are specific to you of what the amenities are, how they are. And you recognize that whatever we're going to do here, however far we're going to go, it's never going to be good enough. You acknowledge that this is a pandemic. This is a virus, a disease that can be passed on from person to person by breathing, by coughing, by sneezing, just airborne with asymptomatic people as well. You recognize the fact that whatever we may do, you may still get that, your family, your guests, and invitees. You recognize the fact that we are not telling you that we can properly and adequately protect the area, yet you're still acknowledging that you're using it, notwithstanding all of that information. And when you put people on notice, when you put out there the limitations that the association has and can enact, and the expectation of the owners on how they should act, you are covering yourself, I believe, to the best level short of closing. And there you're giving people the opportunity and the knowledge that whatever we do, it's not enough. The best is to stay home and not use these facilities. However, if you're going to do that, don't come later and say, you screwed up, association. You put us in a position where we've now contracted the COVID-19 and we are sick and we're going to sue you because one, we didn't come out of it properly, we have lasting ailments, or two, our loved one passed. Does that stop somebody from suing you? Of course not. Does that stop them from getting a large return on their lawsuit, if you will? I believe so. I believe, since we're a comparative negligent state, I believe that when a jury, and these will always go to a jury, sees how much you did as an association to put people on notice that this is at their own risk, that these are the steps that you're able to take and the limitations of those steps, and that still as an owner, you read that, you saw it, it was posted at all entrances, at all areas of the association, mailed, emailed to you, and you still chose to put your family and yourselves at risk. You can't come now to the community and say, give me money, give me damages, you're at fault. I'm an adult, but it doesn't matter because no matter what you told me, you're still wrong. I don't believe that would fly, and I really think it would help insulate the association a lot more. Now, one of the questions I was asked was, how do we make a rule, or should we make a rule that we can enforce, and who would check for compliance? Well, you need to check for compliance. You need to put that in effect. So what I said in the beginning is either have it on video, or you do need to post somebody there for a good portion of the time to observe. Whether you do it by a rover who comes around, you do it by camera only, but with somebody to come there and do so, you need to do that. Now, what do you do when something goes awry and the owner's members are not listening to you or not complying with your demand? It's a great question, and here's how you deal with it. You notify that owner, and I put parentheses with an S, could be multiple owners, one owner, whatever it is, but we'll call it owner, but understand that it applies to multiple people. You notify that owner and that next statement there, why not just keep it closed? We're going to get to that. You notify that owner that they violated the documents, the rules and regulations, the association's authority, and that if it happens again, they'll be banned from coming to the pool. Now, owner complies, it's wonderful. Owner doesn't comply. Not only does that owner not comply, but more and more it's getting lax and harder to get compliance. If that happens, you then will put out a notice to the members and you'll say, this little experiment at XYZ Condo or ABC Homeowners Association, we tried. We went out of our way. We gave notices. We had somebody patrolling. We removed the furniture. We removed the chairs. We removed the tables, everything to make it more amenable to you to have your groups in there while protecting as much as we could, and you still couldn't abide by it. Boom. We're going to close up the facility again until such time as we can try it again in 30, 60 days from now and see if everybody is ready to abide by. If you don't, and if you don't then mandate that people leave, then yes, I think it'll blow open that exposure because now you've lost control. And all the signs in the world, you still have an obligation at the community. And you say to me, Guy, what's this obligation? How much money do we have to spend? So if I'm a plaintiff's attorney, and I've done a lot of plaintiff's work for many of you and for others, if I'm a plaintiff's attorney, I say, well, great. You wrote all these letters, right? You wrote all these signs, you posted them everywhere, you let everybody know. We did, Mr. Shir. Terrific. And what do they say? Well, they say that, got a social distance, 6 feet, no groups of 10, you understand what's going on here. Terrific. What happened? It lasted about a week or two, and then everybody started congregating. And did you know? Oh, of course we knew about it. And does it violate the CDC orders? Absolutely. We are aware, but we told people you have to do this, and if this is at your risk. I understand. Are you able to close the pool at that point? Well, yeah, but we didn't want to. People were so upset. So you knowingly kept your pool area open while people were violating this, even though you knew it was a violation and that something should be done. Well, what did you want us to do? Close the pool? Issue some fines? Suspend rights? Those of you with gate access communities can easily turn off after a proper hearing, can easily turn off a transponder or an access and say to the owner, until you comply, until you stop going to the pool for your suspension of 10, 20, 30, 40 days, you can't come in through the automatic gate. You have to come in through security. You can use other means of, unfortunately, it is what it is, punishment to get people in compliance. And if it doesn't work, then yes, absolutely. As Tom has said and wrote, you close it back up. You close the pool. You close the tennis courts. You close the basketball court. You put tape around the play areas. You need to balance the members' needs with the association's responsibility and liability. And if you do that, I think you'll be fine. If you don't, and it goes one way or the other, obviously you're risking issues. You're risking issues if you're too strict and too stern on it, that boards can be overthrown and people put into the positions where they don't think as much as you're thinking and they're not as attentive as you are, and the association goes to hell in a handbag, as they say. If you're too giving, if you're too lax, then you will see an uptick in lawsuits against the association. And why is that so bad? Because these lawsuits won't be defended by insurance defense, where you pay your $2,500, your $5,000 deductible, and insurance defense takes it over, provides a defense, and then tries to settle with the plaintiff at some point with nominal cost to the association. You will be hiring your association attorney, and you will be looking at damages to be special assessed from all of the owners except the plaintiffs. And that's a huge hit for any community to take. So what do I recommend? And I'm going to leave you with this if there's not any more questions. I'm recommending that if you're going to open up any of your facilities, that you come up with a plan of action of use, that you come up with a plan of action of clearing that facility for anything that allows people to simply linger, put their stuff on, and things that have to be cleaned and disinfected throughout the day. I'm going to suggest that if you don't have the money to put in a full-time person there or a roving person there, that you put in a camera. There are plenty of cameras out there right now that are on Wi-Fi, wirelessly, that you can do and monitor at a central location for either at the guard gate, or you may have to do it at for the management company and tie it in somehow. We don't know how long this is going to last. We don't know how long we're going to have to take care of these issues. So you need to be prepared. And when I'm looking at a plaintiff side of this, and I'm asking you, how much is your landscape budget? How much is your, beautification budget? And when I see that it's in the tens of thousands of dollars, and we're talking about a Wi-Fi system that's a couple $100 and maybe a remote access for some signal out there for another few $100, and $10 a month for a signal to be put there if you don't have it around to tie in. When I'm looking at a nominal cost, it's yet a cost, but nominal compared to your landscape, your beautification, your trimming of your bushes and so forth, then I'm looking at a really good argument to be made that you should be spending the money there instead of where you are now to protect when you're going to open up the pool, tennis court, basketball court, and play areas. Because now you have told me that we have the money, we simply choose to spend it elsewhere. So with that, I leave you. I'm going to update with some cases and some other issues that are going on that are non-COVID in the next few days. I'm hoping to post a few videos this weekend that won't be live, but will be available on the channel, including a podcast that I'm going to do. And I always try to convert these into podcasts after the fact so you can listen to them if you didn't have an opportunity to watch. I thank you so much. I don't see any other questions. Anything, any questions? Let me put here anything, any questions. So I really encourage your boards to sit down in a live meeting, obviously, if you're not doing it in person, so people know that you're meeting. The only time you can't, as you know, is when you meet with counsel over legal matters. And this would be a legal matter, by the way, because you're looking to do and enact things that would potentially avoid litigation in the future. And these are issues that may be litigated in the future. So clearly, we would do it that's a proper way to do it. They'd still have to be noticed. But I really think boards should come up with ideas on how to, kind of like the governors do, kind of like the mayors do, come up with a plan of reopening parts of the association, come up with how we can do it, present it to the owners and say, look, here's what we can do. Here's how we can do it. If you abide by this, it'll continue. If you don't, we'll have to close it back up. And with that, seeing no other questions, I want to thank everybody for joining us today. Always feel free to call me, email me. If I can help draft for you, if I can help come up with some ideas like I have for some of my other associations, I'm happy to do so. Please subscribe. Please stay tuned for other postings. And again, be safe, be healthy. And as I like to say, any day above ground is a great day. And today I'm above ground. So thank you for that. Have a wonderful day. And God bless everyone.